The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 908. Coming to you on Monday, the 6th of August, 2018. On this program, I will speak to you on the topic, the CCJ Part 3. But before getting into the topic itself, a few preliminary comments. Firstly, my condolences go out to all families which have suffered recent bereavements. Secondly, I would like to send heartiest congratulations to Bishop Noel Clark on his appointment as Acting Governor General. He is now His Excellency Bishop Noel Clark. Congratulations on your appointment, my good brother. And let me take the opportunity to explain to you, the listener and the viewer, that there is a difference between the office of Deputy Governor General or Governor General's Deputy and Acting Governor General. You see, the Constitution provides for us to appoint a Governor General and also a Governor General's Deputy. The Governor General's Deputy would normally fill in for him when he's absent, or even if he's present in the state but is not available to go to a function, the Governor General's Deputy could go in place of the Governor General to represent His Excellency. But when both the Governor General and the Governor General's Deputy are out of the state, then the Constitution provides for someone to be appointed Acting Governor General until such time as His Excellency returns to the state. You recall that the Reverend Victor Job had been appointed as Acting Governor General some time ago in the recent past. Well, Pastor Clark, Bishop Clark, my good brother, Your Excellency, I wish you all the very best for the time in which you would be acting. Finally, I want to commend one of my spiritual Baptist brethren, Pastor Brian Turton, on an excellent message he delivered yesterday during the radio broadcast service at his church, Mount Sinai Spiritual Baptist Church of Lago Heights. I, of course, was not present in the morning when the service was carried on, but I listened, as I usually do, to the rebroadcast on Sunday night at 8:30 on NBC Radio 705 and listened to the entire service. Quite enjoyed it. But Pastor Turton, Leader Turton as he is more familiarly known, has been one of my favorite preachers. I like the way he takes a simple concept and explains it in painstaking detail and brings out the gospel message that way. Congratulations, my brother. May you continue to grow spiritually. Okay, I now come to the topic for the evening, the CCJ Part 3. As I said on the last program, different people have different opinions on the CCJ. And even though there are quite a lot of us who advocate that St. Vincent and the Grenadines should accept the appellate jurisdiction of the CCJ, there are people who disagree with that and who advocate the opposite point of view for various reasons. But I recently heard from a gentleman on the road. He stopped me and discussed the topic with me. And he is not just against the CCJ as our appellate court, but he's against the very notion of constitutional independence. And then I saw on Eyewitness News an article by a well-known, not well-known, not in the sense that I know who he is because he writes under a pseudonym, but a gentleman, again, lamenting the fact that places like St. Vincent and the Grenadines opted for independence. He said it was a trick by the intellectual classes to get these countries, meaning St. Vincent, places like it, to go into independence. And he cited the case of Montserrat and the British Virgin Islands as places which were still colonies ruled by England, but which he alleged were better off than us here in St. Vincent and the Grenadines. And he impliedly felt that we ought not to have become independent. We should have remained under the British control as crown colonies and not be entrusted with our own destinies. Now, people who hold that point of view, and many other people hold that same point of view, they said, look, we should never have become independent. Since we got independence, look, these countries, these islands have gone down the drain and so on and so on. Many people hold that point of view, with which I profoundly disagree, but it is their right to hold that particular opinion. I side with those who believe that countries have the right to self-determination, and I cherish our constitutional and political independence. I mean, I have been studying, I started studying English history in the year 1960 as a student in the grammar school. In fact, I quite enjoyed history. It became my favorite subject, and I even got a grade 1 level pass at what was in those days the CXC, which would be the equivalent to the CXC. In those days were the Cambridge Certificate Examination. And then when I got to the sixth form for 2 years, I studied European history under Mrs. Norma Keyser, brilliant history teacher, brilliant lady, generally, but history, she made us love the subject. So that from way back when, I have had an inkling of the historical development of the Western world. In my days, we did not do West Indian history in the school, but I, on my own, did whatever readings were available to me. So I've developed a grasp of historical matters. I started studying political science in 1965 when I went to university in Canada. I started studying law in 1970. And constitutional law was a first-year subject when I went to Cave Hill at the opening of the law faculty in 1970. And throughout all these years, I have been involved with the law, student and then a lecturer and then a legal practitioner in the courts, so that I consider myself fairly knowledgeable on matters of the development of civilization. And if it is one phrase that I applaud Dr. Gonsalves for using and using and using time and time again, is the phrase Caribbean civilization. Because he has made us understand quite clearly that we in the Caribbean are a distinct civilization. He always says we are no better than others, but nobody is better than us. So to me, national independence is something that all formerly subjected peoples in the colonial situation should aspire to. And I recall in 1979, In fact, even going back before that, when we got statehood in 1969, I was thrilled. For those who don't know, Premier Cato had appointed me to head the Statehood Celebrations Committee as chairman. So I organized all the statehood celebrations, and if you can retrieve a recording of the lowering of the British flag and the raising of the statehood flag, it is my voice you will hear on that recording, narrating the progress of the statehood flag being raised. And then when we got independence in 1979, I cut short my studies in England, came home in time for the independence celebrations and also to contest the 1979 elections. So that I am thoroughly familiar with our development, with our history, with the notion of self-government, of sovereignty, and therefore I am steeped in the belief that a formerly subject peoples, upon the attainment of political independence, ought to go all the way and become totally independent. I made a statement, and I have made it time and time again, that until we here in St. Vincent and the Grenadines achieve, as part of the Caribbean Brotherhood, total assimilation in the Caribbean justice system at the highest level, that we are still not fully independent, because our final appeals go to the Privy Council, which makes us not fully independent. While we have a regional appeal court, which has in the past 13 years of its existence has proven itself by all measures. It cannot be said, the CCJ cannot be said to be a court that favors governments. It has ruled time and time against governments. I came across very recently a ruling of the Privy Council against the government of Belize. This decision was delivered by the CCJ, ruling by the CCJ, not the Privy Council. This decision was delivered on the 31st of July this year, a few days ago, where the CCJ struck down the notion that a judge appointed to the Court of Appeal by the Belizean Prime Minister is not answerable for alleged shortcomings which occurred before his appointment. In Belize, their constitution gives their Prime Minister the right to appoint the Court of Appeal judges. Now, that is not something I necessarily agree with, but it is part of their law. But there was the CCJ ruling against the government of Belize. And guess what? The brother of the Prime Minister of Belize is a member of the CCJ. He's a judge on the panel of judges for the CCJ, Justice Barrow. His brother is Prime Minister. He, of course, could not take part in the hearing of the case involving his brother, Prime Minister. But here are a panel of judges, having among them a brother, that is a brother judge, who happens to be the brother of a Prime Minister whose case comes before them. And the CCJ did not hesitate to practically slap the Belizean Prime Minister in his face by saying, no, notwithstanding you appointed this gentleman as a judge who had alleged shortcomings before his appointment. The CCJ said the way should be open for those shortcomings to be investigated, and if found to be true, for the authorities to govern themselves accordingly. So another decision delivered by the CCJ on the 18th of July last month from the Court of Appeal of Barbados. And the CCJ in that decision made a ruling against the interests of the Barbados government. Now, it is being said by the opponents of the CCJ in its appellate jurisdiction that there were two litigants from St. Vincent and the Grenadines who, it is alleged, couldn't get justice in the courts of the Eastern Caribbean and could only get their justice in the Privy Council. So that is regarded as a reason why St. Vincent and the Grenadines should not accept the appellate jurisdiction of the Caribbean Court of Justice. Now, I congratulate all litigants who have won their cases in the Privy Council. But there was the Privy Council on the 9th of July this year, which is last month, hearing an appeal from the former registrar of Anguilla. She lost her job as registrar, went to the courts of the Caribbean, of the Eastern Caribbean, and they ruled against her. And she then went to the Privy Council to seek a justice. And the Privy Council ruled against her as well. The Privy Council said the Eastern Caribbean Court of Appeal was correct in ruling against you, the lady is Mrs. Harding. So that the fact that some cases are won and some are lost doesn't go to show that something is inherently wrong with the Caribbean Court of Justice. People win cases before the Privy Council, they lose cases before the Privy Council. And the two Vincentians who won their cases in the Privy Council could well have won their cases in the CCJ had the CCJ been the final appellate court instead of the Privy Council. There's nothing to say that their arguments would not have prevailed on the CCJ the same way their arguments prevailed upon the Privy Council. Now, I keep seeing references in the literature in St. Vincent and the Grenadines to the question of a referendum. Some people feel that if we are to go into the appellate jurisdiction of the CCJ, we ought to have a referendum to achieve that. Well, that point has been decided by the Eastern Caribbean Court of Appeal in a case which they heard on the 27th of March 2013 and in which they delivered judgment on the 24th of May 2013. You will find it on the website of the Eastern Caribbean Court of Appeal. It's the Attorney General of St. Lucia's reference. And in that judgment, by a 2-to-1 majority, the Eastern Caribbean Court of Appeal ruled that in the case of St. Lucia, it is not necessary for a referendum to be held for St. Lucia to go into the CCJ. Once, according to the St. Lucia Constitution, they got a 2/3 majority in the Parliament. Now, the provisions of the St. Lucia Constitution, which the Court of Appeal looked at, are very similar to the provisions of the St. Vincent Grenadines Constitution, and therefore, the same reasoning would apply to the interpretation of the St. Vincent and Grenadines Constitution. So that when the Prime Minister said that he would require a 2/3 majority in the House in order to make an amendment to bring in the CCJ, he was speaking on the strength of the Court of Appeal's ruling, which said that we do not need a referendum in St. Lucia, and by extension, we would not need a referendum in St. Vincent, provided that there was a 2/3 majority vote among the elected members of the House of Representatives, of the House of Assembly. As promised last week, I want to read you an extract, and I hope I'll just have enough time. You will find this on the web, on the internet. It's taken from the Wikipedia article on the Caribbean Court of Justice. And the heading is for this section of the article is Support from the British Legal Establishment for the CCJ over the Judicial Committee of the Privy Council for the Caribbean. Quote, paradoxically, even as some within the Caribbean oppose switching from the Privy Council to the CCJ over fears of lessened impartiality by CCJ judges, not as far removed from the region as the Privy Council judges. Senior British legal figures, often members of the Privy Council itself, have expressed support for a regional court for the Caribbean. As far back as 1828, the man responsible for remodeling the Judicial Committee of the Privy Council, Lord Brougham, had raised the issue of removing colonies from the Privy Council's jurisdiction. He opined that due to the distance of the colonies from the UK and the immense variety of matters arising from them, which would be foreign to British habits, that any court in the UK would be extremely inadequate for the colonies. Lord Brougham's sentiments were echoed nearly 200 years later, in 2003, by Lord Hoffman, a law lord, from 1995 to 2009, when he noted that although the Privy Council had done its best to serve the Caribbean and had effected improvements in the administration of justice, the remoteness of the court from the community served as a handicap. In his own view, a local final court would be necessary and beneficial to transform society in partnership with the other two branches of government. In 1990, Lord Wilberforce, senior law lord from 1975 to 1982, and later in 1992, leading barrister Lord Gifford QC, both called on the Commonwealth Caribbean to establish its own regional and final court of appeal. In 1999, then senior law lord Lord Brong Wilkinson described as burdensome the number of appeals in capital matters coming from the Caribbean to the Privy Council. He noted that such appeals occupied 25% of the Privy Council's time, and he felt it was time for the Privy Council to be relieved of the Caribbean cases in order for the region to accede to full legal independence. Lord Brong Wilkinson also advocated for the establishment of a regional Caribbean court of last resort. In September 2009, Lord Phillips of Worth Matravers expressed sentiments close to those of Lord Brown Wilkinson a decade earlier. Lord Phillips, the last senior law lord and first president of the Supreme Court of the United Kingdom, said he would be searching for ways to curb the disproportionate time that he and his fellow senior justices spent on hearing legal appeals from independent Caribbean countries to the Privy Council. He expressed concern that the new Supreme Court judges would end up spending as much as 40% of their working time on Privy Council business, and was intending to take pressures off the Supreme Court judges by drafting in lower-tier judges from the Court of Appeal to sit on cases from Commonwealth countries. He also added that in an ideal world, former Commonwealth countries would stop utilizing the Privy Council and instead set up their own final courts of appeal. In October 2009, Lord Gifford, at a reception in Kingston, Jamaica, again expressed support for the replacement of the Privy Council by the CCJ. Lord Gifford noted that the CCJ would be more accessible, affordable, and provide a better quality of justice for Jamaicans and other former British colonies in the Caribbean than the Privy Council. Lord Gifford expressed support for Lord Phillips' earlier comments and hoped that they would serve to stir Jamaica and other Caribbean states to leave the Privy Council and join the CCJ. Lord Gifford also said that his arguments in support of the CCJ were strictly practical and not based on the Privy Council's composition or being a colonial court. So there are senior British judges telling us we should use our own final court. And you find Vincentian saying, no, let us cling to the apron strings of the Privy Council. Well, as has been mooted in England, one of these days, the British themselves are likely to abolish the Privy Council. And if they did that, those of us who still carry final appeals there would have no choice but to use the court, the final court we have, the CCJ. Are we going to wait till Britain closes down the Privy Council before we see the good sense in assuming our collective manhood, our nationhood, our sovereignty, and have our own final court of appeal? I leave you to ponder that, my brothers and sisters. So, ladies and gentlemen, brothers and sisters, boys and girls, that brings me to the end of tonight's program. I look forward to being of further service to you next week, Monday Divi, for another presentation in this public service nation-building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls. Happy birthday to special people born in this day many years ago. Until then, may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.